Appreciate your patience. You were here quite early. We talked about not only how we handle the endorsement process, but also how we're going to handle informing others of who our endorsements are. Are we up and running? Cool. I'm glad I didn't say anything.
The front will be edited.
Thank goodness. And about some of my other remarks too. But I realize, Jacob, this is the first time you've interviewed with us. So again, thank you for taking time out of your schedule. I guess it was on camera, but you had indicated you had several different events tonight, as you do most every night. So
I appreciate the opportunity. I really do.
Our pleasure. Regarding your decision to run, why did you choose this particular race at this particular time?
So one of the things that I find particularly concerning is the legislature's action last session to change when judges are elected. So now we have all 52 judges here in Clark County that are up for election every 6 years, and it's all at the same time. So if you don't like a judge, you do something now about it, or you have to wait 6 years. I thought that was an interesting move. However, that's not the reason why I jumped, but there was a reason why I chose to do it now. I've always seen myself, I've always seen the judge as a natural progression for me of the legal field. I am somebody who is, I like to think, academic. My writing is, I would say, above average. It's often described as academic. I'm constantly tackling cases of new impression. For example, this Friday I'll be before the Nevada Supreme Court on a matter of first impression. I'm before the Nevada Supreme Court probably 4 or 5 times a year, as well as the Ninth Circuit 3 or 4 times a year. It's something that I'm attracted to. Cases of constitutional importance, administrative matters, regulatory issues, overreach of government, business disputes. Those are the real issues that I gravitate to. And so it was never a surprise that I would run for judge or want to become a judge. It was just a matter of when. And I use the timing now. Why I chose Department 22 is because I was not always a litigator. I was a transactional attorney for years, did complex transactional work. For example, when the M Resort was being built, I was the one who papered the subordinate second-tier financing between MGM and the M Resort, and I papered it in 4 days, and I was very proud of that work. And I was the one that my firm turned to make sure that we got that critical piece of financing work done, and in a fast and efficient manner. That was what I did. In 2008, I had a very good friend who was a physician. He was brought into this community to teach advanced laparoscopic gynecological surgery. Nobody was doing it in the market. He was a professor at Baylor and in Texas, and he was taking out hysterectomies and having his patients back to work in 3 days. Unprecedented work. And they brought him here, and I guess he ruffled a few feathers because of his skills, and UMC destroyed his career. And when I heard what happened, I said, well, that's not fair, that's not legal. And he said, great, let's sue. And I said, I don't even know where the court is. And he said, learn, I'll be patient, nobody else will help. And I knew the law was on our side, I just didn't know how to litigate. And so I did what most attorneys should do. I opened up the rules of civil procedure. I didn't have a mentor who taught me all of his bad habits in litigation. I went straight to the rules. And I realized very quickly I'm one of the few attorneys in Nevada that does that, that follows the rules. That's a personal pet peeve of mine, and that's one of the things I want to bring to the bench.
Because that's one of our other questions. So.
It is a requirement for following the rules, because it really destroys the legitimacy of the judicial system when litigants see the rules and they see that they're not being followed. But my very first case was a petition for judicial review in front of Susan Johnson against UMC's actions. And I was there with my client. I actually brought my clients to to cases. I thought clients should be in the courtroom when their motions are being heard, which is also something that doesn't occur often. And Susan Johnson mocked me. She ridiculed me. She cut me off in the middle of my legal argument, and she ruled against us and dismissed the case. To the point where my client walked out of the room with me, the courtroom, and said, "That was fixed, wasn't it?" I don't know if it was fixed, but I can tell you that I do know that I've been married long enough to know that I'm wrong on occasion. I'm okay with that. What I'm not okay with is cutting me off and not letting me advocate and do my job for my client. And that's what happened in Susan Johnson's court. It turns out when we filed the 1983 action for civil harm in federal court on the same matter, then it's gone all the way to the Ninth Circuit, and the Ninth Circuit said that it is indisputed that UMC violated my client's constitutional due process rights. Now, constitutional violations are the essence of what a judicial review is for. And so not only was Ms. Johnson, I didn't agree with the way she handled the case, but she was wrong on something as critical as constitutional rights. And from that moment on, I always preempted her. So I never appeared before again. And I've thought, well, maybe it's just me. But I hear over and over and over from attorneys who are not with big firms, who may represent the little guy, who are there for the true interest of justice, that she does this to attorneys all the time. Matter of fact, recently somebody called me, and he was against me in a case. I mean, really, we were harsh adversaries in this case. And he calls me up and says, "You're not going to believe what just happened to me in Susan Johnson's courtroom." She cut him off, and she goes, "Blah, blah, 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 blah," just mocking him. And I said, come on, you're exaggerating. He said, "I'm going to order the video transcript from the records and give it to you as my campaign gift to you." And he did. And I have that. It happens all the time. And I just believe that there are attorneys who ramble in court. There are attorneys who go off on tangents. It's not inappropriate for a court to redirect them to the matters that are of import for a motion or a hearing. But to mock, ridicule, and cut attorneys off when they're simply advocating for their clients, to be wrong on basic constitutional law such as due process, we deserve better for our community, and that's why I'm running.
The public, by and large, doesn't have a lot of interaction with judges. You yourself said clients usually aren't in there. Clients are a very small subsection of the population as a whole. Really, the only window into the judiciary is, the much vaunted RJ biannual evaluations that come out, and that recently came out in 2013. Obviously, it's not a perfect system of rating the judges, despite its name. What insights do you feel can be gleaned from those evaluations, and how, from what you know of how they are performed, what would you do to try and educate the public regarding what information perhaps isn't contained or isn't available?
Let me take the second part first. In this day and age of computerized records, I find it amazing that you don't know how many cases a judge has in front of them. You don't know how many motions to dismiss are granted versus denied. Now, the amazing part is every time you file a document, you have to put in the document code. So the whole thing is tracked in the system, but we don't have access. We don't know how many cases as a percentage are appealed. We don't know what the overturn rates are. We don't know any of that common, basic statistical data of how cases flow in and out of the courtroom. I think that's wrong. I think that society, as the funders of the judicial system, have a right to know how the courts are working. How many cases are you hearing? What type of cases are you hearing? And so I blame that on the courts. I blame that on the administrative courts. And I make campaign promises, but I will say, if I get elected, I will try the best I can to make that data transparent. And I will work. I know that there are committees amongst the judiciary. That will be my #1 initiative to try to bring some transparency to what judges do. It's not hard. It won't cost any additional resources. We have the data. It's just not being published and mined and published properly. That would be a huge first step in really creating some objectivity to rating judges. There are certain judges that I'm before that start their courtroom at 9:30. They'll hear 3 motions. They'll break for lunch, and they'll come back for an afternoon calendar, and they're out by 4. There are other judges I know that start at 8 and work all the way through 6 or 7 at night, and really produce a lot more than their counterparts. If we had a way to track and rate the work product just through simple demographic numbers, you'd start to see trends, I believe, that would help when combined with peer reviews and attorney reviews would give better insight. I do have a problem though with the RJ process, and I've spoken with the RJ about it, because, for example, I as an attorney take the instructions fairly straightforward, and I try to follow them. So it says only if you appear in front of a judge. Well, let's look at Susan Johnson, the incumbent in my race. I said I preempt her every single time I get her. So I'm never before her. So I haven't rated her. Haven't rated her in years. So you're only getting the people rating you who want to rate you, good, bad, or indifferent. There are some people who will take the opportunity to shoot at a sitting judge and are very harsh. But for the most part, you're there in front of that court because you want to be in front of that court. You have chosen not to preempt that judge. And therefore, overall, I think the ratings are inflated to the positive over the negative.
For what it's worth, for the non-attorneys in the room, preempting a judge essentially means this. When a case is filed, you're randomly assigned to one of however many judges are in the pool. You end up with Judge X. Before anything happens, you can say, I want anyone but Judge X.
And you pay a fee, $450, and they will reassign you to randomly, allegedly, to another judge.
Yeah. So that's what a preemptive challenge or a preemption means.
One of the interesting things is you could preempt in certain categories. From what I hear in the construction defect department, though, they've stopped allowing preempting, which I don't agree with that. And that's a concern of mine as well. And Susan Johnson hears a lot of construction defect cases.
Every so often, judges are called, whether they're civil only or 50-50 departments, they are called upon from time to time to take overflow cases in the criminal arena.
Right.
I don't know how much experience any you have in that area. Assuming you find yourself in that position, how are you going to navigate those treacherous and unknown waters?
I chose the civil department because that's what I practice in. I also chose the civil department because I was a paramedic for 15 years. And I worked in cities like Washington, D.C., Atlantic City, Cleveland, and I treated hundreds of victims of crime as a paramedic. So I have that perspective, and yet on the other hand, probably about 80 to 90% of my cases involve constitutional rights and defending constitutional rights and promoting due process. I've got to say, if there's ever a person who's split between two different sides, it's me, because I believe in the need for due process and fundamental fairness. But I don't have a soft spot for criminals, for people who engage in violent crimes, because of as many people as I treated. It's going to make it very difficult for me, extremely difficult for me. I could tell you, though, that if I am assigned an overflow case, I will make sure that, above all, that person's constitutional rights for due process and fundamental fairness are protected. And I think as long as we are protecting their opportunity to be heard in a meaningful manner, which is something I do in the regulatory world all the time, whether it's a doctor that's accused of some kind of act and his medical license is at risk, that's most of what I do. in that world. It's still the same basic fundamental due process system. And so I think I will be able to manage that, and I'll do what I did when I started litigating in civilly. I'll open the rules of criminal procedure, and I'll try to follow the rules.
For what it's worth, it's very rare for a pure civil department, depending on reassignment, it's very rare for a pure civil department to get an overflow case. An overflow case occurs when a criminal judge has, for example, 2 trials going the same week. So he or she can't hear both trials, obviously, so they send it to a judge who does not have a trial that week and is willing to accept it. So that's why, even if a department is purely civil, if a judge doesn't have a trial that week and there's too many trials to go around, well, good. Then congratulations, it's a boy, is really what they kind of tell you and let you ferret your way through. So,
Right.
Clearly you've been in and out of the court system. I mean, you've done a lot of litigation, not only in district court here, but also Ninth Circuit and other
Federal.
arenas.
I'm also licensed in New Jersey and Pennsylvania, as well as the U.S. Patent and Trademark Office. And so, last spring, I spent 8 weeks living in a hotel room in New Brunswick, New Jersey, as I, by myself, litigated a discrimination case on behalf of an Indian woman who was a physician who was completely discriminated against by the University of Medicine and Dentistry of New Jersey. And we won a $1.6 million jury verdict for her. So, it's interesting. A lot of attorneys will only sit in the court where they're comfortable with, because they learn the judges, they learn the rules. I actually enjoy getting out of my comfort zone, because I think it makes me a better attorney. When I have to make sure that I'm following new rules or learning new systems, I think it makes me better. And so I learned a lot from that court case, but I think it made me better for it.
Seeing all those other judicial systems, for lack of a better term, what do you see as the biggest inefficiency here in Clark County? And assuming if you're
Inefficiency
elected,
or flaw?
well, all right, we'll go either.
Flaw, the biggest flaw is that we have elected judges. And when I told my wife I was going to run, she said, "Are you crazy? You hate elected judges." And I said, "Well, I haven't gotten appointed as an Article III federal judge yet. So if I want to be a judge, I've got to stand up and try to fight for it." And that's the system we have, but we should not have elected judges. It should not be a popularity contest or based on how many signs you could purchase, whether or not you're going to win. And I say that knowing that I have a substantial number of signs out there. But that's the system. I think the largest inefficiency in our court system, the largest inefficiency in the 8th Judicial District Court, I think is the lack of uniformity amongst the departments. For example, 2 weeks ago, I tried to get 2 different injunctions. One was against the State Board of Medical Examiners on behalf of a minority physician who, for the 3rd time, they tried to destroy his career. For that doctor, I was just in December received an opinion from the Supreme Court of Nevada, which overturned the board's actions against him, which is the only time the Supreme Court has ever overturned, reversed, and remanded the medical board's actions against the doctor. I was very proud of that. And then the next board meeting, they went and nailed him again, and I went and filed an immediate lawsuit. And we got the injunction, which is almost impossible to do against an administrative agency, especially one that's there to protect the public, allegedly. But at the same time, I was going to get an injunction on behalf of a case you may have heard of, the puppy case, where we were trying to stop Clark County from taking somebody else's property and giving it to their own contractor to raffle off for the benefit of that contractor. And at the same time, I was trying to get an injunction on behalf of a casino who I represent, who found out that one of their contracted restaurants was not paying the union dues as they were required to do, and caused my client, the hotel casino, to be in major default of their collective bargaining agreement. And so we were trying to get an injunction from them, basically liquidating and running with all their money. 3 different cases, all 3 required the same relief, based on the same case law, based on the same procedure, and yet all 3 cases, my office had to develop, and I had to develop different orders. We had to approach the system differently. We had to jump through different hurdles based on what judges were assigned to those cases. And it made it very difficult. That's a problem. And I fault the courts for not relying on the rules of civil procedure as the basic fundamental guide as to how the courts work. If we were all playing off the same rule book, that wouldn't have happened. And unfortunately, it has become, you have to know your judge and know what they want, or call up the JEA, the Judicial Executive Assistant, or the law clerk, and try to sweet talk your way into the chambers to find out what they want. That's wrong. And that's the biggest inefficiency I see.
So there'll be no sweet talking?
I have a really hard time with ex parte communication.
Ex parte means when one side's talking to the judge without the other one present.
I was in chambers with the opposing counsel before a judge 2 days ago, or yesterday, and the judge is just talking about, to the opposing counsel about their law partners and this and that, like they're best friends, and clearly this was not the first time they spoke, and I'm sitting there thinking, I've never been in your chambers, I don't know you, you don't know me, there's clearly a disparity in that. I've seen gifts, flowers, candy, wine delivered to chambers all the time on behalf of law office. I've never done it. I don't think it's appropriate, but yet judges accept it. I don't believe it. It won't happen in my court.
What is your thoughts on the RJ 4-page article? Yeah, so
I'd rather not
just,
comment.
okay, because
well, let me say
it
this.
is a mess. Yeah.
Let me say
Because
this.
because they said that people should start, judges should be appointed in so like that's what the RJ said.
I agree with
The
that.
main reason was that. That's it. Very subject. You just said it should be appointed instead. You just mentioned a few minutes ago.
I can tell you that nothing in that article was surprising to me as a candidate. Let's just leave it at that.
I know the whole story, so I'll just leave it at that.
Considering this magical device to my left, that's a very appropriate answer. And I apologize, I kind of bogarted most of the questions. Other than that one, did anyone else have anything to ask? Because we're coming up to about, usually we had 45 minutes blocked off, assuming there would be 3 people.
I have a question.
But please, Kate.
I'm going to go back to the inefficiencies, right? You say that with the age with the computer age, all this should be transparent. Now, transparency is something we consistently hear. What makes you think, or what will you do when you are elected to make this transparent and to make it happen?
Well, and I've got to say, I've never been a law clerk. I've never worked as a judge. So I don't know what kind of reports the individual departments get with respect to their caseload now. They may already be getting these reports. They may already know these numbers. And it's just not being turned over to the public or released publicly. If that's the case, I will work within my power to at least release the numbers for my department. At the very least, release those numbers. If the reports are not being generated, then I will be working with the IT department and the clerk's office to try to get very basic information. How many motions and of what kind are being filed in my department every month? What's the average length of time that it's taking to resolve those motions? How many continuances are being...
So technically it's for your department only?
start with my department.
Yeah.
All right, and then push to have it throughout the court system. There's no reason why it's not publicly available.
I do like to hear which judges that you mentioned that work real hard on the bench. I believe they deserve an applause, which usually people don't see, right? Yeah, I hear lazy one, I hear hardworking one. Oh, which is a hardworking one? I don't care about lazy one. That's it.
And I'm sorry, I think I know what Jacob's gonna say, but I have to cut you off.
Let me.
Well, in
There's
general,
an
you
issue.
can't.
You can't.
Yeah.
You can't generally talk about a sitting judge, make an endorsement, make a.
I see.
But I will say this: it will be a tremendous loss to see Alan Earl leave the bench, and so he's leaving, so I can say that.
Yes.
Alan Earl, if you can ever think of somebody as a jurist, is the essential jurist. He was intellectual, smart, well-reasoned, a very, very nice temperament, and he didn't treat you differently if it was the first time in your courtroom or if it was the 8th time in your courtroom or the 80th time. He was somebody that I look up to, and I felt it was a privilege to litigate in front of him. One example.
Thank you.
How was that?
Didn't think you would step on it, but I want to explain it to Kevin, but you took care of it. Well, again, Jacob, I know you have other events tonight. I appreciate you making time out of your schedule to meet with us.